Good afternoon, everyone. My name is Dan Korb. I'm here to moderate our 10th part of our series of webinars, Fraud in the Time of the Coronavirus, Preventing and Confronting Selling Away and Ponzi Scheme, Regulatory Issues and Claims. And with me today, we're going to be covering several topics. We're covering supervisory tips, claims and investigations, what happens in the arbitrability of claims. And today on our panel, I want to introduce all of you to my colleagues, David Buffa, he's a principal in our New York office, Joel Everest, who's a principal in our Alabama office, Mark Knoll, another one of my principals in the New York office, and then Sarah Soto, she's a principal down in our Miami office, and Kerry Zinn, a principal in our Fort Lauderdale office. So with that, I will turn it over to Mark and Kerry to get started on the discussion of supervisory tips. And I want to remind everybody that if you have any questions along the way, there's a note box along the side. Please put in the group chat any questions you have, and the panel will do their level best to answer whatever you may have.
Great. Thanks, Dan. So, as everybody understands, this is a time of obviously great anxiety with the coronavirus, with the response to the pandemic, with the uncertainties that still surround it all. And market volatility and uncertainty is certainly prevalent. And just overall, there's a very high risk environment out there for the financial markets, and especially for firms involved in the financial markets, both our broker-dealer, our investment advisory clients. I mean, anybody who's out there recognizes that there are these inherent uncertainties out there. And when you have these inherent uncertainties, when you have heightened risk overall in the marketplace, we wanted to bring to this webinar series and highlight the risks associated with that. And certain of those risks we certainly see as being questions involving either selling away, Ponzi schemes, or other involvement by your registered representatives or by your employees within your firms in activity that's going to expose firms to regulatory and litigation risk. Because we tend to see upticks in this sort of activity, unauthorized selling away, unauthorized outside business activities in times of economic distress. And as I said, for broker-dealers, it's not just the external bad actors that you need to be aware of, right? It's not necessarily the third-party fraudsters, but you always need to be vigilant for them. But you also want to be, as our regulators would tell us, on the lookout to maintain strong supervisory practices to watch over your own people, right? Because your own people are experiencing the same sort of economic uncertainties and the same sort of issues that we are all facing. And to the extent firms can be vigilant to make sure that even though we're working remotely, even though there's these economic uncertainties out there, that their registered representatives, that their employees are well supervised and following the rules, the litigation risk, the regulatory risk is minimized as best you can find it. So the core supervisory tips, and we're going to start off really with the regulatory overview and focus on what the core supervisory expectation for broker-dealers are, certainly from FINRA's perspective. And the core FINRA rules, as most of the folks on this call will know, and if you don't know, here they are. When it comes to outside business activities and private securities transactions, the two core rules are Rule 3270, which addresses outside business activities, and Rule 3280, which addresses private securities transactions of your registered representatives or associated persons. I'm sorry, of your registered representatives. Rule 3270 requires that registered representatives do not conduct business activities outside the firm without, one, providing notification to the firm, right? So notifying the firm that they are engaged in this particular outside business activity. And then number two, they have to obtain approval for participating in that outside business activity. Now, there are some nuances to this. There's types of activities that fall within the scope of outside business activity and some that don't. Certain charitable endeavors, depending upon what you're doing, might fall outside the scope of those things. But generally speaking, if you've got somebody who's involved in a business activity for some sort of remuneration, or they control the funds of some sort of an organization or control the investment decisions of an organization, if it's charitable or otherwise, that's an outside business activity, and that requires approval, notification and approval by the firm. The next core rule is 3280, right? That's the private securities transactions rule. And there we're not necessarily talking about an individual registered rep buying or selling securities in their own account. What we're talking about is a registered representative who is arranging outside the supervisory scope of the firm, or outside the firm's approved products, outside the firm's approved securities. They're engaged in a transaction, either for most of the time for compensation, where they are arranging a securities transaction, and they're doing it outside the supervisory purview of the firm. For private securities transactions, again, it's not necessarily that they are flat out prohibited, but you do require, or regulators require, that notification be provided to the firm and approval be acquired before this registered representative, before any registered representative is permitted to engage in a private securities transaction. And then, of course, FINRA's core supervisory rule remains, and you should all know it well. It's FINRA Rule 3110. That's the core rule that requires firms to have a reasonable system of supervision to make sure that the activities of their registered representatives and their associated persons conforms to the rules. Conforms to the Securities Act, conforms to the Exchange Act, conforms to FINRA rules. And what the supervisory scheme, or what our regulators require for our supervisory protocols, is that those supervisory protocols have a reasonable control in place to identify outside business activities, or undisclosed outside business activities, or undisclosed private securities transactions. Now we'll talk a little bit more about exactly what that means. And so, Carrie, can you tell us a little bit more about specifically when it comes to selling away? I mean, what is it that what does that mean, and what are firms really looking for?
Sure, absolutely, Mark. And as Mark indicated, we're in highly unusual times, perhaps the biggest national crisis that's happened, potentially, arguably, from World War II. And as a result, the fraudsters are coming out of the woodwork and trying to take advantage. The SEC issued an alert on April 10th to investors about possible COVID-related schemes. And one of the things they mentioned in their alerts, and we agree with, is that there's going to be an uptick in unregistered private offerings that are COVID focused. For example, how it would play out would be potentially there would be a private offering for a company that has, a miracle drug for COVID, or perhaps a company who claims that they've created, a very inexpensive, latest and greatest ventilator. And that's really where we think the selling away will come into play, is that there's going to be unregistered offerings that are COVID focused. And given that we're in a climate where people have many fears and hopes, the fraudsters are absolutely going to be trying to take advantage of those people's fears and hopes during this crisis. And so essentially, from a supervisory perspective, what you should be focused on looking for, amongst other things, with regard to selling away is, financial advisors who are offering their clients, private offering, typically unregistered, in exchange for compensation without disclosing the activity. Now, needless to say, that creates a lot of potential regulatory and litigation risk. Often these unregistered offerings are fraudulent, and many times they end up turning into Ponzi schemes. So it's simply, the classic fraudulent unregistered offering, but with a new spin focused on COVID is what we're expecting to see. As a result, it's really important for firms to be mindful as to, potential red flags that a financial advisor has an undisclosed business activity or undisclosed personal, securities transaction and is offering, unregistered private offering to clients of the firm. And there could be a variety of ways in which, this activity can be spotted. For example, is correspondence coming to the branch, to the financial advisor, addressed to the financial advisor, discussing a product that is not offered by the firm or not part of the firm's books and records? Are there clients calling and making inquiries to branch staff regarding products which are not offered by the firm or on the firm's books and records, such as an unregistered private offering? Is there sales literature in the broker's office or in some other location? Sometimes it gets found on copiers, things like that. And then ultimately, one of the key places to always be mindful with regard to red flags of an undisclosed personal securities transaction or outside business activity is, of course, email. Email is a gold mine for regulators, and oftentimes it has cropped up in many of enforcement cases where the email's flagged and the email has been discussing an offering or a security that's being sold to the client that is actually selling away, but then the email is not appropriately escalated. So I really think that, you know, the unregistered fraudulent offering related to COVID is going to continue as a potential risk for as long as we are going through this crisis. And then, whoops. Firms, of course, as Mark mentioned, need to have written supervisory procedures that address, you know, personal securities transactions and outside business activities. In particular, those procedures should inform, you know, the branch personnel, the supervisors, the managers, the admin managers, with regard to what the specific red flags are that they should be mindful for, you know, as part of their reasonable supervision. What to do when they come across a red flag, what actions should they take, what steps do they need to do to discharge reasonable supervision. And those procedures, you know, the supervisory procedures should also lay out, you know, what investigation steps should be taken. There's a number of them, and my partner David Buffa and others are going to cover them in detail in a moment. But, you know, the investigation is always critical. Targeted email reviews, speaking to staff members, contacting clients. But the most important tip I can give you from a supervisory perspective is document the review no matter what, irrespective of whether or not you conclude that it is not in fact selling away. The reason being is, of course, because if you are wrong, even though your actions were reasonable, you know, you want to have that evidence and that backup to show that you acted reasonably. Because unfortunately, although, you know, supervisors, you know, try to supervise to all of these things, it's often the case that even with a system of reasonable supervision in place, sometimes these things can't be detected, or ultimately sometimes the wrong decisions are made as to whether or not it's actually occurring. So again, even if you conclude it's not selling away, you know, have your documentation, your memo written up, your backup as to your conclusions, and that will certainly assist the firm in the event of future regulatory risk or litigation.
Yeah, and certainly one of the things that is important when it comes to mitigating that regulatory litigation risk is to make sure that your supervisory system is nimble enough, is flexible enough, and reasonable enough to be able to deal with situations that come up, to be flexible enough to, in a situation like we're in now, nobody's expecting that you take your entire written supervisory procedures and you update them immediately to start putting in independent, different COVID-19 or pandemic response policies in place. Not for your whole WSPs, but if you are responsible, you're sending out notifications to your supervisory team, right? You're letting them know what our regulators are telling us. You're advising your supervisory team through either blast emails or through other sort of compliance updates. That will be that good augment to your supervisory system that will allow you, if a regulator ever does come and ask you questions about how you adapted your supervisory policies to the current environment, you'll be able to say, look, no, we've been paying attention to what our regulators have been saying. We've been paying attention to what is out there in the marketplace. We are disseminating that information to our supervisors so that they can be more aware of potential red flags. As Carrie just said, to be more aware of potential unregistered offerings involving the next miracle company that has the best new ventilator or the next vaccine. Those sorts of updates, you know, either through, like I say, emails to your supervisory team, emails to the field, those sorts of touches are very important, even if it doesn't require, like I say, a wholesale, you know, revamp of your written supervisory procedures. Again, our regulators do not expect perfection, right? But they do expect you to adapt to the environment, to have a reasonable system in place that will, you know, best protect your customers and best enhance, you know, your overall supervisory regime.
Yeah, and ultimately it's going to be the same generic indicators of red flags associated with an unregistered private offering. So you're going to have those hopefully already in your supervisory procedures, and then as Mark indicated, you know, just sending out bulletin and notices reminding people of the fact that, you know, the new hot issue is going to be COVID. And of course, there are certain supervisory best practices that should be adhered to in order to protect the firm and ensure that you're discharging your supervisory responsibilities. A great best practice that many firms do is to have financial advisors complete an annual questionnaires regarding outside business activities or private securities transactions. Ask them whether or not they did any during the year without disclosing them, or if they have any updated activities that they need to disclose. And ultimately, financial advisors should be required to attest to that information, that the information that they are providing is accurate and complete, so that it makes them realize that they do need to disclose this activity, and they should not be doing it, outside of the firm without the firm's approval. And ultimately, one of the things that always makes a lot of branch management teams uncomfortable is the subject of discipline. That being said, and I get it, right? Nobody likes to discipline their employees overly much, but if there's an undisclosed business activity or an undisclosed private securities transaction that takes place, then the regulatory expectation is going to be that some measure of discipline was imposed, perhaps, a letter of reprimand or something else like that. That all helps to show reasonable supervision, and of course, make sure it's in writing and that you keep it on file to demonstrate the action that you could take.
Thanks, Kerry and Mark. That was extremely insightful and helpful, and I think we all got a lot of value out of that. For those who are seeking CLE for this, which we're offering, the first code will be, which you can find in the notes section, will be surprise. And with that, I will turn it over. The next part will be the claims and investigations and what happens, and that'll be presented to you by David Buffa and Joel Everest.
Thanks, Dan. Hi, I'm Dave. Joel and I are going to walk through so the way that you address these issues when they bubble up, either in the context of a customer complaint, a red flag that's referred from another department, a whistleblower, or an internal or external auditor that discovers an issue, and now it's time for the firm to address it. So when these issues come up, I think that there's a natural drive, particularly for the in-house folks, to fix the problem and then quickly move on to the next thing. But due to all the different legal and ethical pitfalls and potentially corporate politics that are at play, when you rush to fix a problem and don't account for all the potential collateral impact, it can end up causing more work, but also it can exacerbate what the potential damage is. So what we have here, we've put together some points for basic tips and thoughts for starting an investigation and what you need to think about and consider to do it the right way. So obviously you want to get up to speed quickly on the facts, but before you start interviewing witnesses and reviewing documents, you want to ask some basic questions like who knew what and when. And that's not just like who are the relevant representatives or clients, but particularly when you deal with a bigger firm that has affiliated entities, or like a parent corporation that has their own committees, you want to be sure that this issue has not been escalated under some different channel and either addressed and disposed in a committee meeting, or even potentially reported to a regulator because a division of the firm was operating like a silo. And that's those types of considerations aren't dispositive, but they'll dramatically change the course of the way that you proceed in the investigation. So you want to know who knew what and when, and then you also want to start scoping the impact and potential harm caused by the issue. So were customers harmed? Was it more than one customer? Is it something that's still going on? And if that's the case, it's going to rapidly change the timeline of your investigation. And whether or not it's something that was discrete and happened in one occasion, or if it's something that was systemic and impacted a number of different clients from one FA or a whole group. So those are like the basic considerations to have at the outset, and then you want to start putting together your players list. So is the representative that you believe engaged in this selling away misconduct, is he or she still at the firm? Or is she gone, and did he or she bring her clients with them? So are the clients still clients of the firm, and then people that you can easily reach out and talk to, or are you going to have to go through a different channel to conduct those fact interviews? And then another initial consideration that you want to have in a conversation with the client at the outset is, what's the final product going to be when you're done with the investigation? Are you going to give an oral presentation to the client, to a board, or do they want something that's memorialized in a written memorandum? So all of these basic considerations are really going to shape the way that your investigation progresses. And that dovetails into the next slide here, which touches on everyone's favorite subject, cooperation credit and self-reporting. So you think you have an employee that's engaged in misconduct, and what do you have to do in terms of telling your regulator about it? So you've got essentially 30 days from the point at which you know or should have known that a violation occurred that was widespread or implicates a significant dollar amount or a material system failure. And once you self-report, that's an important strategic moment where you want to have comfort that you've really scoped the issue and have a plan to deliver to the regulator if it's not addressed already. So cooperation credit is something that has been discussed at length since FINRA first came out with a relevant notice to members in 2008. And cooperation credit has been something of an elusive concept where firms typically feel like they've done the right thing and self-reported and tried to address the issue in a way that's reasonable, but will be surprised when FINRA says, thank you very much, but we don't believe that your cooperation was extraordinary. We think that what you did was appropriate and in line with your regulatory obligation. We think that you are being a good member firm, supervising your employees and doing what you're supposed to do, but what you did isn't extraordinary. So the problem with extraordinary cooperation when you're trying to achieve it on the back end is you might have missed that opportunity if you don't plan for it at the beginning. So in the summer of 2019, FINRA issued another notice to members that gave some additional insight into what they're looking for when they're examining their relationship with the member firm for cooperation credit. And the takeaway was, you need to go above and beyond what your regulatory requirements are. So if under Rule 4530, you need to self-report a conclusion that a violation has occurred, that's going to be viewed as your regulatory obligation. But if you self-report, you concluded that there was a violation, and you independently undertook a larger review of the system and independently remediated or have a definite plan for remediating customers that were impacted by the violation, it's that is what FINRA is going to look at as cooperation that's extraordinary. It's self-reporting with a bow on it. There's nothing else you need to do because we've done everything you could ask of us and more. So while it continues to be something of an elusive concept, there's really no downside to planning at the outset that you're going to try and achieve extraordinary cooperation credit, because if you fall short, you're likely to get some kind of credit, whether or not that ends up being memorialized in a formal aspect in the settlement document.
David, is there some instances, we hear that it's an elusive concept, but are there a couple instances that you can maybe describe for everybody where firms have received cooperation credit?
Yes. So over the last year, FINRA and the SEC have both taken up a really helpful practice of putting details in settlement documents when firms have achieved cooperation credit. And they say, the fine here has been reduced. They won't say the specific amount or what the percentage is or anything like that, but the fine here was reduced because the firm self-reported the issue, paid back all of the impacted customers, and importantly, actually, one thing that comes up in the notice to members and is frequently mentioned in the settlement documents is undertook an independent investigation. So it wasn't just an in-house review. The firm hired an outside law firm or an outside consultant, and that independent body conducted an investigation. So that, in some recent speaking engagements, folks from FINRA have said, without being explicit that it's required, it's really important that the investigation's independent if you want to get cooperation credit. So with that also flows into the next slide that Joel is going to discuss about FinCEN reporting and other requirements under NTM 1918.
Thanks, David. And like you were saying, with the cooperation credit aspect and with really so many aspects of these types of investigations and issues, you want to get out in front of it, immediately. And one of the things you're going to have to do as soon as possible is determine reporting obligations under the Bank Secrecy Act, which requires reporting in certain situations through SARS. So notice to members 1918, you can see this slide, talks about some required instances of reporting if the conduct involves a broker-dealer, which obviously is the type of situation we're dealing with here, aggregate funds of 5,000 or more, and suspects the transaction is against a regulation or law. And notice to members 1918, it highlights a number, really dozens and dozens of potential red flags to look for in these situations. So that can be a good resource, while it's certainly not limited to just Ponzi schemes or selling away issues. It goes far beyond that. But those red flags can be a good resource for things to be on the lookout for. And there's about 20 that specifically relate to securities trading and about 30 listed in that notice to members that relate to money movement, which of course can be an important indicator of a Ponzi scheme type activity. And one of the red flags specifically mentioned in there relates to wire transfers or deposits coming in that are irregular and perhaps going out of the account immediately or on a quick basis. Sometimes you'll even have memos on checks about an investment or purchase, things like that. So those are all things to be on the lookout for and to determine whether or not you need to be filing a SAR under the BSA and under what's there in Notice to Members 1918. And like I said, like David said, that's something that has to be determined, and you have to make that assessment as quickly as possible. Turning slides now, we've been focused mainly on the regulatory aspects, dealing with regulators with these types of issues. But of course, the other side is litigation. You might have litigation only, you might have a regulator come knocking only. You may be just dealing with an internal investigation before either of those things happen. And then of course, any combination of regulator and litigation only, regulator only. But when that litigation piece comes into the puzzle, just like with the investigation and just like with dealing with the regulator, you've got to assess the facts and get as complete a picture as possible so you can know what you're dealing with and try to react accordingly. So we've listed some considerations here from a litigation standpoint. which is a little more focused on exposure. So trying to get information as to the number of clients that might be involved, the dollar amount. So we're talking about one client who made a $50,000 investment in an unregistered, security, or a security that's not offered by the firm, or are we talking about 100 clients who've invested $100 million collectively? So you want to try to get as good of a handle as you can on the number of clients involved, dollar amounts, and again, going back to those red flags. Obviously on the front end, you want to be looking out for them and developing your procedures and spotting those as best you can. Once litigation comes in the door, you need to look backwards. See, was there anything that perhaps should have been spotted? Perhaps there was a prior complaint that came in that may have been denied. There may have been, it may have just been viewed as a smaller issue. And now with new information, viewing that in retrospect, perhaps, more should have been investigated at that time. Looking back at the branch exams, looking back at money movement issues, all of the red flags we've been discussing, take a look back and see if there's correspondence calls, the emails, and see what sort of issues you might be confronting in the litigation angle. What's a claimant or plaintiff's lawyer going to be pointing to that here's where the firm failed, and that's why they are liable to us for our investment losses. So it's always good to get a handle on those as early as possible. And we're going to talk about document gathering in a little more detail later, but we've got it here to you want to gather those relevant agreements. You want to know exactly the language that's in there, setting forth the firm's duties and obligations. We'll also, Sarah, my colleague, is going to talk about arbitrability later. You want to make sure you've got a handle on exactly which agreement is going to be in effect in terms of the arbitration provision. Is there an arbitration provision? And if so, take a look at that language. Make sure you're familiar with those issues as early as possible. Carrie talked about attestations earlier. That's another document, along with the agreements. Go ahead and see if you have those attestations on file as to whether there have been outside activity. If you've got those certifications, that can obviously be an important document. But you want to go ahead and gather those, and that's going to help you assess the potential exposure, and it can tell you how much in terms of resources you need to be devoting to this. If you get a handle on the number of individuals involved, dollar amounts, and react accordingly. Protect the firm and put yourself in the best situation to defend claims that are. And then, of course, part of that is going to, once you're investigating, you're going to have to interview folks, and Dave's going to talk back on that.
Right. So this is like the fun part. So you spent a lot of time putting your plan together, and you and the client are on the same page, and now you get to talk to people. So we're going to start with considerations when you're interviewing. Indicated that they understood the terms of the upjohn, whether or not they had any questions, and then you can begin your interview of the witness. And one thing that I think is helpful to bookend an interview, and you can build it into your upjohn and then repeat it again at the end of the interview, is that the employee needs to keep the conversation confidential. So that has a number of different impacts. One of them is you want to make sure that employees aren't spreading rumors, they aren't talking about the investigation, and you also want to make sure that, in part because that could have impacts on the privilege, but it could also have an impact on recollection. So you're talking to people, and they say, "Oh yeah, I remember talking to Joe about this." And they say, "Well, that's a long time ago. How do you remember that?" "Well, I was talking to Joe about it yesterday at lunch." You say, "Well, geez, that's not going to be helpful when you have a complex set of facts and you're trying to dig into events that may have occurred a long time ago. One of the difficulties when you are, particularly when you're an outside investigator who's interviewing a current employee, is you have to ask sometimes tough questions, and you have your job and your duty is to be a fact finder, but you don't want to be an interrogator. And when you have to start an employee interview with an upjohn, sometimes it can have a chilling effect, particularly with employees that aren't sophisticated or used to dealing with lawyers. So one thing that we try to build into the practice that we found is helpful is you before you give the upjohn warning, you describe that I'm about to tell you something that's really important and you need to understand it. But the thing I'm about to say to you, I'm ethically required to say it, and it's not just for you. It's not specific to you. It's something that we have to tell everybody that we talk to, and that can ease the sting of getting a potentially scary disclosure before you talk to a lawyer you've never seen before. In addition, as you're going through your potential witnesses, sometimes it's generally helpful to start with the peripheral players who can give you some of the background and foundational facts before you start talking to the more critical interviewees. And that way, you don't have to waste time when you're talking to the critical folks going over basic stuff. And you can also demonstrate that you have a proficient grasp on the facts that you're going to be talking to them about. Okay. Oh, and actually one other important consideration: 99 times out of 100, the upjohn is delivered and there's no issues. But every once in a while, someone says, "Wait a minute, I'm not comfortable talking to you. Why do I have to talk to you? What obligation do I have to cooperate?" And one thing that's generally helpful is to look at the employee agreements or the employee handbook before you start an investigation, so that if there's something in there about cooperation, it's an easy way to cite it and diffuse that at the outset. Okay, so then you've got your witnesses that you interview, and then you've got your documents. So Joel's going to talk more about that.
Yep, and touching back on document retention, this is probably one of the simplest and easiest topics we'll hit on throughout today's presentation. You can see at the bottom last bullet there, document retention. If you destroy or alter documents, that's going to be a problem. Don't do it. Section 802 of Sarbanes-Oxley. In the federal criminal code now to add 18 U.S.C. 1519. So obviously you want to practice that and communicate that to anyone and everyone. But then of course, looking back at the top, you do want to be cautious regarding recipients, regarding scope and how you disclose. Like Dave said, you don't want the situation where you contact an employee to have that interview and the response you get is, "Oh yeah, we were talking about this at the water cooler yesterday." You don't want a situation where there are rumors flying around the firm that may or may not be true. So you can help manage that by just exercising caution about who needs to get these types of notices and who doesn't. And of course, the most important point is you have to the document contain, identify what's going to be relevant potentially, and make sure those documents are retained. Whether you're dealing with litigation, regulation, you've got to get to the core facts of what's going on. And the documents, of course, are going to be critical for that. On related note, how do you gather the documents? Carrie mentioned earlier, emails. Those are going to be critical in almost all cases, in email search, text and phone messages as well. But, obviously we're into 2020. I feel like maybe 10 years ago in the case, the time periods at issue were 5 years before that in the early 2000s. Maybe it wasn't completely as commonplace today to have all communications flowing through email, but of course that is the case today. Is the vast majority of communications are flowing through email. You definitely want to check text and phone messages as well, particularly if someone's trying to avoid detection. They might, opt for a personal email address. They might opt to send text messages or use the phone only. So those types of searches and developing search terms based on what you've learned, and to the extent you're developing additional facts and learning new things about what is at issue and who is at issue, adjust those search terms to try and capture. If you see, if you find a new document and they are using some abbreviation for the security at issue that you had never seen before, you may need to go back and run a new email search or a new word search with that abbreviation. And of course, as with all aspects of these types of investigations and responses to regulatory inquiries and preparation for litigation, privilege is a big issue. It can be critical to maintain privilege while you're learning these facts. So you want to make sure that your employees are acting pursuant to attorney instructions, and you want to make sure that the investigation is being conducted for the purpose of obtaining legal advice. Those are going to be critical factors in any ultimate challenge to an attorney-client privilege. And I believe it was Carrie that touched on this earlier, and Mark probably as well, but you want to document your investigations, you want to document your process. So in the event that, their example was, if you find that there is no issue and later it turns out that somebody disagrees with that, you can help use that to show that you've been acting reasonably. So in that documentation process, you want to help reinforce privilege. You can document that as instructed by attorney, we're taking steps X, Y, and Z. You can document that we are investigating such and such so that we can get legal advice. And having those in the documents themselves can be critical to that privilege. We've talked about money movement a few times now, but in terms of identifying those facts, beyond the emails and text and phone messages, search for third-party recipients that might be common, irregular, unusual activity in terms of cash flowing in, cash flowing out. Are there memos referencing the word investment, stock, something vague along those lines? If there's third-party banks, or not even necessarily a bank, but any sort of third-party recipient that is not a typical type of recipient, not a major bank where it's spoken to regularly, that can be a place to focus your search and help develop those facts further, so you can get that full picture of exactly what you're dealing with and how you need to respond. And then Dave's going to touch now on a final point in terms of the investigations, which can also be extremely important, and that's how to let folks know about what's going on when you get to that point where you have to loop in certain individuals, whether they're an employee or a customer, and how to handle that effectively in order to protect the firm and avoid exposure.
Yeah, and we're running a little short on time, so I'm going to breeze through these with just a couple high level points. Obviously, when you have an internal investigation that's going on, there's privacy concerns, so you don't want to disseminate information to the public without having a degree of confidence that you've got control over it and that you know something has occurred that necessitates reaching out to a client or to an FA that's potentially no longer with the firm. In the context of clients, it's fact finding, but it's also relationship management. And just as much as current employees don't like talking to outside lawyers, clients don't necessarily want to get interviewed by a lawyer. So one tip is that to the extent it's possible, having a branch manager reach out with a script that you provide that's a general client contact review that explores around potential issues that's of concern. And then finally, with FAs that are no longer with the firm or that are hostile, you need to be careful about contacting clients and drumming up a defamation claim that you are the genesis for. Defamation claims and alerting clients to claims that otherwise would not have had a basis. So a lot of things to consider when these claims and investigations are going on. And then once you get to the next step, that's where our partner Sarah is going to cover some helpful tips about arbitration and litigation.
Unmuted myself, I hope. Hello, everyone. So Mark told you, and Carrie talked to you as well, about the fact that regulators are not expecting perfection, they're expecting reasonableness. My part of this is to discuss your first approach when you deal with the people who are expecting perfection, and those would be the claimants' attorneys that file claims against the firm. These are the first slide outlines some of the considerations I think you should take into account when you have received a claim from someone that has bought an investment outside the firm that they are claiming that they lost money on and that they want the money from you. And so in some of these circumstances, unlike in the usual situation in which we find ourselves, you actually have a choice regarding the forum you're going to be in. In other words, you can be a FINRA or you can be in the court. So in order to make that determination, I think there are some points that you have to consider. First point is always going to be what the cost is of being in one forum versus the other. I think that if somebody is making a claim against you that is for $250,000 or less, you very definitely have to consider very seriously litigating the claim at FINRA, because if you do it in court, the cost is just going to be prohibitive, it seems to me. So you want to consider, and I think this is very important, whether this is a case that is going to draw publicity, what you think about that publicity. Obviously, FINRA arbitration will provide a more private proceeding than what the court is going to provide, where all records are public. You want to consider how good your legal defenses are. You may decide that a judge is going to be more sympathetic and more rigorous in applying the law than an arbitration panel is going to be. So if you think that this is the kind of case that might get you a summary judgment, the courthouse is the place to go. The FINRA arbitration will never get you the summary judgment, as you know. And if you are thinking about going to the courthouse, you want to think about what court you're going to be in, state court, federal court. Does that make a difference to you? And not to be overlooked, of course, is the fact that if you are wrong in your evaluation that this is a case that is going to be dismissed on summary judgment, you're going to be facing a jury trial, which is, since you're probably wealthier and larger than the person that is suing you, they're likely to be more sympathetic than you are. So it's definitely something that you want to keep in mind as you're making your decision. You want to take into account the identity of the attorney for the claimant. Some claimants' attorneys are accustomed to practicing both in court and arbitration. Some are not, and might find themselves, you know, a little lost in one forum versus another. And then last but not least, and I think this is also something to think about, what have been the results in FINRA arbitrations involving selling away claims? We did a small survey, a review of FINRA awards over the past 5 years that we could identify involved selling away. You can't always identify, obviously, given the nature of the awards. We eliminated from our sampling, we eliminated cases that would reflected a settlement. We eliminated no-shows, and we eliminated dismissals for eligibility. That left us with 23 awards over the past 5 years. Of those 23, 8 were denied. They were 0 awards. The other 15 were awards for the customer. And of those 15, 3 included punitive damages awards. So this may be something you want to make a note of, so that when your business people come to you and say, why the hell should I pay a settlement? In this case where, you know, I was selling something that the firm does not sell, and the broker was doing something that he's absolutely prohibited from doing, well, you may want to say that, you know, not everybody may look at the situation the same way, and that every case has to be evaluated based on objective facts to the extent possible, and not on the understandable frustration of being sued by someone who at times was not even your customer. All right, so now let's say that you're evaluating where you want to be, where you can be in terms of a forum. And FINRA Rule 12-200 is going to come into play. It's going to tell you that a member or associated person must arbitrate if the arbitration is required by a written agreement or if it is requested by the customer. If the dispute is between a customer and a member, that would be the firm, or an associated person of a member, note the or, and if the dispute arises in connection with the business activities of the member or the associated person. So I tried to change that, but it didn't work. So let's see if I can go back. All right, first you have the situation where the person does have an account with the firm and the person does have a written agreement to arbitrate claims with the firm. You will, in that case, be entitled to be in arbitration, and if the customer chooses to be in arbitration, you'll be required to be in arbitration. One exception: if a claim is filed in court and it is filed as a class action, whether putative or certified at the end of the day, you are not allowed by FINRA Rule 12-204 to move to compel arbitration. You will have to remain in court and litigate there. If the claimant files in court and you do not have a written arbitration agreement, then you will stay in court. You will not be able to compel arbitration. Sometimes you have situations in which multiple claimants file in court. Some have agreements and some do not. You can move to compel arbitration, obviously, as to the ones who do, and you cannot as to the ones who don't. Keep in mind that there is the possibility of your asking the court to stay proceedings as to those claimants that do not have arbitration agreements while the arbitrations are pending, in the event that there are common issues that are going to be determined. The policy favoring arbitration does give you the opportunity to ask the court to stay everyone's claims while the arbitrable claims are determined first. Then the last situation is a situation in which you have a claimant that has no account with the firm or no written arbitration agreement, and that claimant files with FINRA. Okay, and here's where the choices can actually be made by the firm. And the case law on this, how can I put this? Okay, so here's where you get into the area of angels dancing on the head of a pin. Okay, the rule seems fairly straightforward, i.e. is the person a customer? And unfortunately, the rules do not define customer in this setting, other than to say that a customer is anybody that's not a broker or dealer. And the second thing that the rule provides for is that the activity that you're being sued for has to be in connection with the business activities of the member or the associated person. The courts have disagreed about how broadly to interpret this language. Generally speaking, most courts define one who purchases services from a FINRA member in the course of the member's business activities, or one who has an account with the firm, as being a customer. But this has been given various interpretations. And of course, once again, you can imagine your business person coming to you and saying, okay, so we have a reasonable supervisory system in place. No, there were no red flags during any of this time. The investment that was sold was not an investment sponsored by the firm. There was no way for me to know what the FA was doing. Why am I here, right? Well, you may still, you will find, be required to arbitrate in these situations. The cases have gone both ways. There's a very recent case from February of 2020, of this year, the Next Financial Group versus GMS Mine Repair and Maintenance case. Now, that case is truly a nightmare for folks who don't want to arbitrate claims of non-customers. In the Next Financial Group case, the broker had an outside business activity involving the development of a mine. The broker had disclosed to the firm that this was an outside business activity and that he was doing it away from the firm. He persuaded someone who was not a customer of the firm, or I should say someone who did not have an account with the firm, to invest $3.5 million into the development of this mine. And of course, the mine turned out to be a Ponzi scheme, and the financial advisor was, criminally prosecuted and put in jail and had no money. So of course, the customer came looking for Next Financial Group as the deep pocket to sue, and filed a claim in arbitration. Next Financial moved to enjoin the arbitration in court, saying, this person never had an account with me. I don't sell these investments. There's no basis for FINRA jurisdiction. Surprise, there was a basis for FINRA jurisdiction, the court found. The court grounded its finding and its refusal to enjoin the arbitration on the fact that Next Financial is, after all, in the business of selling investments, and the financial advisor was selling an investment. Therefore, the court reasoned that the person was a customer, and this arose out of the business activities of the firm, so it had to be arbitrated. I would say this case is really at the extreme of allowing arbitrability of claims by non-customers, but it's out there and it's the latest case. Mr. Korb?
Okay, thank you, Sarah. The hour. Our last code will be consequences. So the first code was surprise, and the second code is consequences. And for those of you on the call, I want to invite you to our next week's webinar. It'll be the 11th in the part of our series put on by Bressler, Emery, and Ross. And the issue will be turning the page on COVID-19, employment issues businesses will face as the country gets back to the quote-unquote new normal. So thank you everyone for participating today, and it was our pleasure.
Thank you, everyone.